Ladies and gentlemen, welcome to our part 3 of our REHDA webinar series, especially on this subject called Property Industry Updates Coping with COVID-19, which is the current temporary measures for reducing the impact of coronavirus disease 2019. Now, last week in our part 1, our discussion was focused on the COVID-19 Act itself and its impact on the professional services. We also touched on the limitations and rights of the parties involved. And at the same time, we did touch a little bit on the construction industry and construction contracts. But today, I think we are going to be especially more targeted on all the various issues that arose as a result of the impact of COVID-19. Since the construction sector at large would also be affected by several sections of the COVID-19 Act. So we have gathered together today a lineup of experts on the related field, and which will hopefully help to answer some of the questions that you have posed. Now, participants who would like to ask the questions, you can actually start jotting down on the Q&A section, and we will pick it from there, and then we will post it to each of the speakers themselves. All right. Now, in this session itself of our webinar, we will be looking at the full impact of the COVID-19 on construction contracts and construction disputes. As we all know that Section 7 of the COVID-19 Act itself touches very, what you call, on the surface of the construction contracts and the construction supply contracts. So maybe this may not be sufficient enough to gather a lot of understanding about how it's going to help and how it's going to assist the various construction sectors. Now, we hope today's session will then help to address and clarify your doubts pertinent to the construction contract itself. Now, on the panel itself, we have Mr. Rajendra Navaratnam. He is a partner of Asman Davidson and Company. We really need no introduction to Mr. Raj. Yes, he is actually the foremost one of the exponents of construction contracts, right? And the other speaker will be Dato Engineer Soam, who is our REHDA president, and he will also be most useful in helping to relate between construction and property development. And also on our panel itself, we have Mr. Oliver Wee from Master Builders Association. We will then seek the various views, especially his experience on the impact of COVID-19 on the, construction industry. And lastly, of course, as usual, we will have our speaker from Maybank, Dato Jeffry Muhammad Ali. And he will actually assist us on the various issues, especially on financing, right? Now, before much ado, we would like to invite Mr. Rajendra to present some of his views on the impact. And over to you, Mr. Raj.
Hi, thank you for the kind introduction, and thank you all for logging in to this webinar. I see there are 218 participants. That's a lot. So I have a few slides to share with you, and I will start it now. Okay, today I'm in. Can you all see the slides?
Not yet.
Not yet. Not coming.
Okay, let me just share screen again. Okay, I think you should see it now.
Yep.
Okay, I'm going to briefly cover a few areas of the COVID-19 Act, which will be of interest to you all. And basically, it will cover the main provision which talks about a temporary relief from contractual obligations at Section 7. I will have a couple of words about the mediation part of the Act. And finally, we'll talk about some of the provisions that relate to the Housing Development Licensing Act, which will be most pertinent to people, members of REHDA. So let's get going. Now, as you all know, there are many dependencies in the industry. There are supply chains, there's material, foreign labor, and COVID-19 crisis has impacted all of these. During the MCO period, there was full-blown suspension of works, and thereafter, even with a conditional MCO, even though works were allowed to start, but there were SOPs to be adhered to, and there are also consequential delays because the delays that took place during the MCO period obviously will have a knock-on effect to the further works, especially the end stage works. And then there are also delays in supplies of materials because many of the materials, if they are imported, COVID has hit hard all around the world. So there will be delays in the supply chain. So the consequences are delay and obviously LAD exposure, both for the contractors who are building for the developers and for the developers to their end purchasers. And of course, additional costs all around, both from the delay as well as for the compliance, the lower productivity because of compliance with SOPs. Now, this is the key provision of the Act, Section 7 of the COVID-19 Act, where it relates to the inability of any party or parties to perform any contractual obligation arising from the categories of contracts specified in the schedules due to the measures prescribed, made, or taken under the Prevention and Control of Infectious Disease Act 1988. Now, and this shall not give rise to any of the parties exercising his or their rights under the contract. So the important things to remember is it applies to, I know the operative section relates to the inability to perform, will not give rise to any rights for the other party to exercise his contractual rights, but it's confined to categories of contracts specified, and it must be caused by the measures taken under the PCID, which is the Prevention and Control of Infectious Disease Act. Now, this will be the biggest hurdle to overcome because not always you can show that the problems that were faced were actually caused by those measures. And the duration, this part is deemed to have come into operation on the 18th of March, which is when the crisis started and when the MCO was declared, and shall continue to remain in operation until 31st of December 2020. So you can see that it is of limited duration to start with. The problem is it only took effect maybe less than a couple of months ago. So the duration is very, very short. Now, the elements of Section 7 are inability to perform, that's obvious, arising from specified contracts. In this case, it would be construction work contracts, consultancy contracts, supply contracts for material equipment, and performance bonds and professional service contracts. Now, this must be due, this is the causation part, it must be due to PCID Act measures to control the disease. This is very, very important because very often some people think it's a get out of jail free card. Something happened during this period, the other party cannot enforce their rights, but they must be able to establish the link between their inability to perform and the measures taken under the PCID Act. And the consequence is the other party cannot exercise contractual rights during this duration. Now, what are the problems? The thing is, the problem with our Act, and I don't know why we confined it so much, which is confined to measures taken under our Act, which is basically effectively only the issues that take place within Malaysia. Now, what about delays due to COVID-19 overseas? Because in our modern world with so many linkages worldwide, especially with supply chain issues, there are bound to be consequences from issues taking place outside. So on the face of it, Section 7 will not apply because it is due to something that has happened outside the Act, not subject, outside the country, not subject to the COVID-19 Act. For example, the Singapore COVID-19 Act is more widely drafted, caused by a full COVID-19 event, which is defined as a COVID-19 epidemic or pandemic, or the operation of or compliance with any law of Singapore or of any other country due to COVID-19. So they have cast it much more widely and has taken care of this particular problem. And then the other particular problem that we have noticed is that there's no remedy for performance bonds that expire during the Section 7 duration. Because you see, you can't exercise your rights, or on the face of it, you can't exercise your rights under the performance bond during this period. But what happens if the performance bond expires during this period? I mean, we have been thinking about various arguments to make, but the problem is it could have been addressed in the Act. And under the Singapore COVID-19 Act, I am sorry to say, because Singapore seems to always get it done a little bit better than us, the issue of the performance bond is obliged to extend the bond 7 days after the expiry of the prescribed period, if requested not less than a period before the expiry of the performance bond. So you see, they have considered this, and then they realized that the prescribed period, which is the period which their measures are enforced, may be open-ended. It may, for example, we now say our act ends on this part ends on 31st December, but it may go on for longer if the crisis demands. So similarly, they have allowed for this in their provision. We don't have any such remedy. And then the savings is not, and this is in my view the biggest weakness of our act. Notwithstanding Section 7, any contract terminated, any deposit or performance bond forfeited, any damages received, any legal proceedings, arbitration or mediation commenced, any judgment or award granted, or any execution carried out from the period from 18 March 2020 until the publication of this act shall be deemed, until the date of publication of the act shall be deemed to have been validly terminated, forfeited, received, commenced, granted, or carried out. So the most obvious thing is that it reduces even further the operative period of the act, because the operative period of the act is set to start from March 18. But if a lot of people, when this bill was being published, saw what this was, a lot of people went out and terminated contracts, called them performance bonds, did all sorts of things. And now the act has come into force. On the face of it, is deemed to be valid. So in a way, if you read this act literally, it means that, say, for example, a termination is valid, where before you could have challenged it to say that you haven't complied with the formalities or you didn't have a right. But again, this is on a literal reading of the act. I am sure the courts will try to water it down in their interpretation. But still, it ought not to have been worded in this way, in my opinion, because it gives rise to a lot of unnecessary complications. Yeah, this is what I mentioned, the Section 10 problem. Protection is ineffective if legal proceedings will be commenced. And the literal reading of Section 10 seemingly validates contract termination, performance bond, and deposits forfeited. So now we come to the second part of it. This is quite an interesting section, although perhaps it could have made it more, given it more teeth. Basically, it says Section 9 of this Act says that any dispute may be settled by way of mediation. That's good. Then parties to meet with a trained and impartial neutral person who assists them to resolve their differences. And the mediator will not impose a decision on the parties. Any resolution must be reached by the parties voluntarily. The mediator will test the strengths and weaknesses of each side, unlike negotiation where communication will be limited. Well, basically, the essence of mediation is there are two types of mediation. One is the facilitative type, which is where the mediator tries to find common interests between the parties to help to move them together. And the second one, which is what this one is leading to, which is alluding to, is the evaluative type of mediation, where the mediator will separately meet with each side and tell them, look, this is the strength of your case, this is the weakness of your case. So they get a reality check, and hopefully that draws them closer to come to a settlement. And that's what it means when you're in a negotiation position. Obviously, you keep your cards to yourself. You don't tell the other side, these are my weak points. And in order to put this into effect, the government has put, through the Act, put into place some support structures. It has created something called the COVID-19 Mediation Center, and they call it the PMC 19 Center. And the government will bear the cost for B40 and M40 categories of individuals, micro and small industries, which claims of 300,000 and below. So it's a fairly low threshold. And for those who don't fall under the B40, M40 category, etc., it's 1,000 ringgit per day. Now, you might also want to consider the existing structures that are in place, which is the Malaysian Mediation Center, which is effectively run by the Malaysian Bar, the AIEC, the MBAM, or ad hoc mediation, which might be, you might just pick someone whom you think might be a suitable mediator to resolve your dispute. Now, the Section 9 problems, some people have criticized it as being no different from the Mediation Act 2012, doesn't give you additional rights, and it is not compulsory. So later on, I'm sure you'll hear from Oliver, who is a big supporter and proponent of mediation. And I think he will also give his views as to what extent, if any, these provisions in the COVID-19 Act will progress mediation beyond perhaps financing smaller mediations or helping smaller players to avail themselves of mediation. Now we come to the modifications to the Housing Development and Control and Licensing Act. Now, the Section 33 defines what agreements are affected by this act, and it means SPAs in the schedules G, H, and I think. Section 34(1), no late payment charges to be imposed due to failure to pay installments from 18th of March to 31st of March due to measures taken under the PCID Act to control COVID-19. So again, whoever wants to take advantage of this provision, for example, if a purchaser wants to avoid late payment charges and says that I don't have to pay because of Section 34(1), I think there's also one more further step to show that you have been affected by the measures taken. Say, for example, because of the measures taken, you are put on no pay leave, or you have had you have been retrenched, or you have something has happened. But in the absence of that, I'm not so sure that they can take advantage of Section 34(1). And Section 34(2) and 3 says that this period, the period on which from 18th of March to 31st of August, can be extended up to the 31st of December upon written application to the minister. Now, Section 35(1) says that this same period shall be excluded from the calculation of time for the delivery of vacant possession or liquidated damages for failure to deliver vacant possession. And similar to 34, 35(2) and 3 says the period for these purposes may be extended at the minister's discretion up to 31st of December 2020, extended upon application extended by the minister upon application to him by the developer. And 35(3) says there's no deemed vacant possession if the purchaser is unable to take possession from the date of the notice to do so if it falls during the period or extended period of the COVID-19 Act. And 36(1), the period that has been mentioned earlier shall also be excluded from the calculation of time for the defects liability period after the purchaser takes possession, or the time for the developer to remedy defects, etc. So you see, the scheme of this is basically to prevent something like a breathing space period. 36(2) and 36(3) again mirrors the earlier 34 and 35 to say that this period may be extended at the minister's discretion up to 31st of December upon application by the purchaser. Now, savings, the modifications shall not affect any legal proceedings commenced, judgment or award obtained to recover late payment or liquidated damages payable by the minister for the period between 18 March to the date of the publication of the Act, and any late payment charges which are paid by the purchaser or liquidated by the developer during this period shall be deemed to have been validly made and are not refundable. Now, the problems, as before, again are in the savings provision, because if the legal proceedings have been commenced, the duration can be severely curtailed. And the literal reading of Section 37 seemingly validates payment made if these charges and damages make them non-refundable. So previously, in the absence of the Act, you could have maybe challenged payments made or and try to get a refund, but now you can't. But I think I didn't mention another problem of some of these these provisions in general, is that how does a purchaser make this application to the minister? You know, it seems to be a bit impractical for an individual purchaser to be making an application to the minister, and how is he going to be dealt with? So, you know, it remains to be seen how this is going to work. And under 16 and 2 of the Housing Development Act, if limitation to a home buyer to file claim expires during the period up to 9th of June 2020, and I don't know why this period 9th of June 2020 was mentioned, the home buyer is entitled to file claims between the 4th of May 2020 to 31st of December, and the tribunal shall have jurisdiction. So the tribunal that hears these claims will have jurisdiction if the claim is filed between 4th of May and the 31st of December. Now, in summary, I don't know, my own personal feeling, and this is not original phrase of mine, it comes from another commentator. He says it's too little too late. I fully agree with him. I'm not sure what the rest think, but that's my view. Thank you very much. I hope I've kept the time.
Okay, thank you so much, Mr. Raj, for your presentation. And we would like to now invite the rest of the speakers to actually give their views on how COVID-19 actually has affected the construction company and also the industry in Malaysia. So we would like to start with Dato Soam. You're ready to present? Yeah.
Muted, Dato Soam.
Okay, okay. Thank you, Dr. Charlie. Good afternoon to everyone. I'd just like to make a few quick comments, and then maybe we can hear from Mr. Oliver. As mentioned by Mr. Raj just now, I think the impact to the supply chain and the property industry and the construction industry is actually tremendous. And as everyone knows, this act coming to force on 23rd of October, as mentioned by Raj just now, too little, too late. But to me, it's too little, too late, definitely. I think we have made a public statement after the 23rd of October. But then what can we do? It's better late than never to us here. Before I even want to continue, this act is going to come to an end by 31st of December. But with the current number of cases still going up, and because a lot of the consequences of the act, if it's due to the PCID Act, then whatever in the clauses can then be used. And I think there are still people who are out there unemployed. And there are also supply chain being affected, especially like Raj mentioned just now. Our act doesn't cover COVID lockdown in other countries. We also have materials coming from overseas that's being affected. So I would say that the current act needs to be extended. Okay, that's my opening remarks beyond 31st of December. Otherwise, we probably have to come up with a new act. This act is actually valid for 2 years, the usage of the act. But come up to 31st December, if there is a new lockdown, say in January next year, okay, the recourse to this act cannot be used, cannot be there anymore, because it's only up to 31st of December. And as you can see from Part 11, affecting the housing industry, per se, between the buyers and the developers, I would think that the inability to perform, and especially not meeting deadline, is still very valid. I think from a recent survey that we did, out of the 130 respondents submitting to us, about 20% of the respondents, of the 120 of them, say that given the exclusion of the 167 days up to 31st of August, and some of them are applying for the additional period to be excluded up to 31st of December, they will still encounter delay later on. That means they won't be able to deliver the units to the buyer. So they may then incur LAD. Similarly, there are also buyers who are not able to pay because they are still out of job, or they have a very serious reduction in salary, especially those employed in a certain sector of the economy. So to me is that we need to see what can be done to actually help to reduce the impact. And as I mentioned just now, the cost level is basically between the relationship, to look at the relationship between the buyers and the developers. What about relationship between the developers and the other supply chain, for example, our suppliers and contractors? And that covered by Raj just now under Section 7, inability to perform in terms of all type of contracts I mentioned there, including professional services and also construction services. And also our relationship with financer, if we are unable to repay, what then can be done? Later on, we'll hear from maybe one of the panelists as well. And to us, is the topic today is to focus more on the relationship between the developers and the contractors, and what are the recourse they are in terms of things related to performance bond, as mentioned by Mr. Raj just now. And also, there's one, I make a public statement previously to say that because of this, this our COVID bill has not been drafted properly, I will use the word, not tidy enough, and because of that, they didn't look at the issues affecting the whole supply chain. Example, there's one clause just now there mentioned about defects liability period, which will now be extended. But the relationship between the contractors and the developers don't take that into account. And the other issue is that a lot of the contractors expect, because 167 days has been excluded from the delivery period between the developer and the contractor. I think some contractors are expecting the same to be accorded, which is not so. It's not covered under the COVID Act. So these are some of the differences we have, and a statement to say that it didn't resolve our issue across the whole supply chain. That makes it a bit more difficult. That's where I would say that a bit of common sense needs to be used. The other thing is on mediation. Mediation Section 9 mentioned by Mr. Raj just now. And mediation is not mandatory. So when it's not mandatory, a lot of things can happen. And we believe because of this, a lot of the contract will become at large at one time or another, and people will be sitting back and see what to do. The other is actually on the COVID, the current COVID bill all have a saving clause, whether it's for Section 10, and also in the saving clause for the property development side on the Section 11, clause 37, we have a saving clause as well. So this saving clause, because our act has been floating the market, the draft act has been floating the market for a long time before the enactment in October. So a lot of people have taken the opportunity because of this saving clause. They just slam it on each other and making it more difficult in the coming days going forward. So basically, this is my wrap up for now, and then maybe later on, if there's question and answer, I would like to maybe answer them. Thank you, Dr. Charlie.
Okay, thank you, Dr. Soam, for this introduction to also the various measures that you wish to impose and ask for it. And also, let's pass it on to Dato Jeffry. Basically, we would just like to see your views on the various measures in the COVID-19, whether it has actually assisted or helped out with the banking industry or the finance side. Thank you.
Yeah, thank you, Dr. Charlie. And again, on behalf of Maybank, thank you, REHDA, for having me also this afternoon. Yeah, I think first and foremost, we all know that the impact of this COVID to the industry, in particular to the businessmen, have been quite huge, right? Now, for the question of whether or not what did we do? Yeah, I think first and foremost, you all see that since the beginning of the MCO's government, I think, had actually come up with a lot of financial support, and this is where banks, including Maybank, we actually support this agenda of the government. I think we all know that there's a fund of say the SRF fund, Yeah, about 2 billion had been disbursed from Maybank itself, just to support the SMEs or those people in needs. And those 2 billion that disbursed, or rather given out by Maybank, actually comprise about, we cover about 3,500 SMEs borrower. So this basically leveraging on the government stimulus package, the SRF. I think there are other fund like agro-food, AF. I think then we have this automation and digitalization facility, ADF, and also, of course, the Penjana fund that was given by the government. So I think we play our part. We disbursed about 2 billion, and I think the current announcement of the TRRF, again, we definitely will be in the market to support our customers. Now, I think how do we further support our customers in regards to getting the accessibility to banking? Number one, I think we have to enhance our process flow. How under this new normal, how do we touch base with our borrowers? So we had to have a virtual meeting with them, a virtual interview, virtual site visit, if I may, acceptance of documents via email. So these are all initiatives that we do for the customers, for the SMEs to basically able to continue the normal banking or submission of their banking facilities application to Maybank. So we basically have like a signing of data offer via a voice call. So we are not like depriving them from, you are not able to come to the bank, but you can still submit your application. You can still fulfill the end-to-end of the application via all these means. Yeah. So with that, I think we're able to again disburse the loan for the customers during this hard time. Yeah. To add to that, to Charlie and the viewers, I guess this is also the period whereby for Maybank, we launch we call it our SME digital online financing. So this is basically a platform whereby a customer can submit their application for the SME financing through online. Yeah, and we was launched in September, 18th of September. The response has been pretty good. Yeah, so far we have approved about almost 3,550 customers, and we have disbursed in the tune of almost 435 million under this platform. So it's basically like we say it's a means to apply the loan to submit to the bank, a loan ranging from 10,000 to 250,000. And we can basically grant the approval within 10 minutes. 10 minutes approval. So this is how we support those customers using our platform. So I would say during this period of COVID, our SME business is in fact is getting stronger. I would say. I think our digital, we are using it through digitally. And our growth is actually double-digit growth. I think we grow about 13.9%. So we do our part to really assist especially the SMEs and the BB customers in the period of hardship at this moment. Dato Charlie.
Okay, thank you so much, Dato Jeffry.
Yep.
For the next speaker is none other than Mr. Oliver Wee, who is the current Vice President of Master Builders Association. And we all know that the construction industry has a lot of issues as a result of the effectiveness of the COVID-19 when it was first came into effect after the gazetting. We realized that the only coverage for construction industry is actually in Section 7. And it's not found as a very specific, application in any of the, subsequent acts. So we would like to now invite Mr. Oliver Wee to see how much actually COVID-19 has affected the construction industry and whether this COVID-19 Act has actually addressed many of the issues that has arisen. Mr. Oliver.
Yeah, thank you, Dato. Now, as you know, the COVID Act merely a temporary suspension for the contracting parties' liability and duties. Even with the COVID Act is expires soon, the industry is still face much uncertainties. such as what EOT to be given, what cost will be shared. Contractor is still looking for reimbursement, but at least an indication of liability. The Act doesn't help us to so-called to give us a clear indication of all the above. So even a very simple fact that is there any way to cap the contractor liability? The contractors are caught with a very little recourse position. It will be helpful if the above are actually clearly indicated and to be agreed among the parties before everyone move on. Another thing is like what Raj has mentioned about the mediation. Well, we always believe mediation is a better option to resolve dispute. But however, looking at the current provision under the Act, mediation is still not so much on the non-mandatory process. So we doubt that it will work much for the dispute that the contracting parties are facing. Perhaps a process that should be recommended into the industry, like a renegotiation process between the contractor and the client, as well as also the subcontractors. So parties should be agreed on certain terms before moving further, because I think the main thing for contractors today is they don't know where their liability is. There's no clear indication. Now, I think that for the rest, we can actually pick up and discuss in detail when there's a specific question asked later in this session. Thank you.
Dato Charlie.
Yep. Yes.
Maybe just to get the motion going, I think that the issue to be brought up, I think people need to know the form of contract we are using. Since today we are focusing a lot more on the construction part of the contract. I mean, in Malaysia, we use a different form of contract, and most of the time for private projects, especially private development projects, most contractors sign the PEM form of contract with either 2006 or 2018 PEM form of contract. And in the PEM form of contract, I think they have actually emphasized that if it's an epidemic or pandemic, is actually force majeure. Okay, in some of the contract, it's not even mentioned that COVID-19 epidemic can be a force majeure. So in this case, I think PEM has now come out and said that it's a force majeure. And of course, force majeure, you have time, you don't have cost and loss and expense and all this. So maybe Mr. Oliver and Raj can give a bit of input on this. I think this is what developers are asking, and the dispute between the contractors and the developers are always about additional time, cost, who to bear the cost of the testing, who to bear the cost of the compliance and all this. I think these are pertinent issues that I believe, to me, since we are now setting the motion in place, we shouldn't sweep it under the carpet. Let's bring it to the open and then have maybe a very frank discussion. And if our member need to sit together and discuss this in more detail, I think it would be good. I can see that they need to understand, because the contract between the developers and the buyers doesn't have a force majeure clause. Okay, but in most of the contract, in the PEM form of contract, is a force majeure clause. So it's a bit different. And the exclusion period of 167 days given to developers by the ministry or by the government is not actually directly given to the contractor, the relationship between the contractor and the developer. And to answer Raj just now, as to why the tribunal date set on the 9th of June is the end of the CMCO period. From 9th of June, the RMCO started up to 31st of August, from 9th of June. So that's when the start of the CMCO. And actually the tribunal actually opened in May. There's another date there mentioned something about May, because the tribunal office is already open since May. So, and 9th of June is actually the end of the CMCO period, from May to end 9th of June. So maybe we can bring it for a more open discussion, and Raj can probably explain what is the force majeure, what is not a force majeure, and all this, so that our members, both from the contracting side and also the development side, can understand it a bit better.
Yeah, totally agreed. So maybe we'll pass it to Raj first.
Yeah.
Mr. Raj, you would like to answer this?
Sure. Well, I think a lot of people don't realize that force majeure is not a concept of law. It is actually a concept. It's actually something that's put into a contract. So it must be in the contract, it's contractual.
Yeah.
So as Dato Soam has mentioned, it is specifically addressed in PAM, luckily, because PAM is the de facto standard form of building contract that we all use. In infrastructure, maybe it might be the PWD, but here PAM is the one. PAM specifically defines force majeure to include epidemics, and it also is one ground for extension of time under clause 23 of the PAM contract. Interestingly enough, it is not a ground for loss and expense under clause 24. So the manner in which the PAM contract is framed, it gives relief in terms of time, but it doesn't give any compensation. And in my view, I think it's a situation which is perhaps from the point of view of the contract form is a reasonable allocation of risk. But from the point of the reality of the contractor's problems, because during that time he's still incurring costs, this is where I feel, it's about, it's time we stop being so confrontational in the way that we approach contracts and look towards the greater good of the project, where hopefully the developer and the contractor can get together and find a way to equitably share the burden during this time. I mean, that's my view. It's very much an Asian way, whereas what we see and what we are encouraged to believe is the kind of the Anglo-Saxon confrontational adversarial way of doing business. One person wins, another person loses. Whereas the Asian way, which is exemplified by the Japanese, for instance, is, if good times, both people do well, bad times, both people try to share the burden, at least in their home countries. So I think that's something that I would very much like to see, especially in a time like this, which it is nobody's fault. It is something that's confronting the whole world. And it's something that we all got to really get together and help each other rather than to fight with each other. That's my view.
How about your views from Mr. Oliver?
You're muted, Oliver.
Yeah, can you hear me? No,
Yeah.
I fully agree with Raj, because fair enough is a contractual provision, usually under PAM. But for a main contractor, with our subcontractors, most of our subcontractors are trade subcontractors. I'm quite sure most of the subcontract does not include what is force majeure. I mean, you'll be happy if they sign a subcontract with you for supplying labor to you. Now, again, I mean, just for discussion's sake, Raj, the PAM form provision is for pandemic or
Epidemic.
Is it a difference between epidemic and the pandemic?
I'm sure that there's probably a semantic difference, but I think for the purposes of, if you ever went to a court or tribunal, I think they will park it under epidemic, because I mean,
yeah,
it's something that, at least PAM has come very close to define, to capturing the situation. It's better than some of the other forms out there.
Yeah, because I was reading some article, it said epidemic is more localized, where pandemic is global, it affects things like that. Yeah. But say what you like, it definitely are not in all the subcontract forms between the main contractor and the subcontractors.
But on the understanding of force majeure, now many contracts would not have this clause, or they would have left it out. Would we say that the COVID-19 Act is actually a sort of like a replacement in a statute form to apply to all the contracts, whether they have a force majeure or they do not have a force majeure clause, that the COVID-19 Act would actually help to alleviate any delays or any what they call stoppage of work, and that each party would not have any claim against each other as a result. So can we say that the COVID-19 Act actually replaces the force majeure clause in most contracts? Mr. Raj, what's your view?
Yeah, I think that was the objective. I think the objective was to provide, some kind of breathing space.
Relief.
So during that time, everything is held in suspense. And I think the only thing that we have against it, I mean, the aim was noble, but the implementation was not so great. And of course, the duration was just too short, because, the pain started in March. on March the 18th. So really, the act is set to be retrospective to March, but then inexplicably it has this savings provision which dilutes most of the effect of the act. So by the time the act was actually published, and as just now Dr. Soam said, it was already publicized, so people were taking advantage of it. Either a lot of contractors and subcontractors would have already gone under by then, or if they had not, people would have begun proceedings against them and they would go under shortly. So it's very sad. I just find it very sad that that the people who drafted this didn't keep this in mind. I mean, the aim was noble, but the implementation was, quite frankly, woeful.
But Mr. Oliver, I think in the calculation of what you call extension of time as a result of COVID-19 Act, do you feel that the 167 days or whether any extension was given do not take into account a lot of other factors like mobilization and so on?
Yeah.
So,
sorry.
Go ahead.
No, definitely is because first of all, I think there is no clear indication of EOT under the COVID Act. And I understand that the contractor are still need to apply under the contract once the act is lapsed. But if you say day-to-day compensation on time is definitely insufficient. We face many disruption delay, such as on the uncertain of SOP, additional condition, which is totally different from what we have tendered. And I mean, put cost aside, the time we definitely need much more than one-to-one due to the disruption.
Okay. For the benefit of the members of the panel, there are some questions that is actually being posted onto our Q&A section. I will be reading some of them and see whether each one of you can actually give your views and answers. All right. Now, question number one, there was a question which says, defects liability period will be extended 167 days to all customers under Schedule GH, who entered into SPA before the 18th of March. However, the Act is silent on the similar extension by the main contractor to the developer. In this case, the developer is on the losing end. What is your view on this and how to handle this? I think this question could be directed to Dato Soam.
I think I mentioned earlier on that the COVID bill is not all-encompassing. It doesn't look at the whole supply chain. And this is one of the main pertinent issue that I brought up. So on one aspect, I think as a developer, the 167 days exclusion given to you in your completion period between you and the buyer, you have taken advantage of. So in this instance, I think the government has asked for a similar period to be given back to the buyers. And also in terms of giving extension of time, I don't think that many of the developers are going to give the contractor 167 days. Mr. Oliver, correct me if I'm wrong. And so there has to be some sort of a negotiation or commercial consideration, as mentioned by Raj, the Asian way of doing things, to look at what sort of extension of time you're going to give to your contractor, and whether your contractor is willing to give you extension to the defects liability period as well. I think these are things that need to be addressed, and something that I think we have mentioned all along, even in our public statement, that everybody has to come to their senses. And this is the part where sometimes mediation is required, or some form of resolving it. In our case, I think the BIPC has actually asked PAM to help up in trying to mediate some of these issues. And I think this specifically talk about the period between 31st of March to, from 18th of March to 31st of August, and this 167 days. And to me, definitely there is a gap in our COVID bill that doesn't address this issue. So the original form during our initial discussion with the Ministry of Housing is not this way. It actually covers the thing perfectly. But when the real act came out, it has all been changed and amended. I don't know why. So sometimes things are not as what we wanted.
Okay, and another question is, this is dedicated for Mr. Rajendra. a developer enter into a PAM contract with contractor to complete a project. Due to the MCO and SOP, the contractor has to spend the cost for COVID-19 tests for all the workers, preparation of the site and enhancement of workers' quarters for the ongoing project for the compliance of SOP. The question is, number one, is this cost contractually right to claim back from the developer? And number two, in the event of COVID-19 case reported in the site and being locked down, is a contractor able to recover the cost from the developer? So there's two stages. One is to start the work, right? So that they have to actually undergo a sanitization as well as also COVID test. The other one is in the midst of construction itself, someone gets infected and suffers as a result from COVID. Then to sanitize again and to actually having COVID tests again, who will have to make all these payments, right? Mr. Raj?
Actually, it depends on the contract. I'm assuming it's the PAM contract. Under the PAM contract, I think there's no particular provision that I can see that's obvious for them to make a claim, for the contractor to make a claim under the PAM contract, because under clause 24, other loss and expense, it says that they are only able to make a claim for loss and expense for specific sub-clauses under clause 23 and for no other. So in that sort of situation, the situations under clause 23 do not cover this particular additional cost of testing, etc. So they might be entitled to time, but I don't think they're entitled to any cost. That's my view. Subject to what perhaps maybe Oliver might have a different view.
Yeah, Mr. Oliver, you have any views on this?
Well, I think the contractor has took the initiative, many of them has took the initiative to start testing without getting or not getting the reimbursement on such thing. Because the objective is to start work and not to have further delay. Of course, we are looking at maybe a compassionate ground to get some reimbursement or sharing the costs. But, I mean, there are always a professional come and tell you that you can claim. And there's a provision under that is totally working under a different site condition. So we still explore. But the best way is to sit down and renegotiate, to share costs or whatsoever, rather than throwing out a big fight between the people.
Okay.
I think the part two of the question just now, Dr. Charlie, is reinfection now. I think if there is due to negligence of non-compliance to SOP and the workers' accommodation and the workers get infected after work has already recommenced, then I think the claim from the developer may be a bit difficult. It's due to negligence or due to non-compliance SOP. But the other aspect is actually the periodic testing. I think currently now it has been made mandatory in KL, Negeri Sembilan, Selangor, and Penang to have mandatory testing for all factories and the construction site. And we mentioned to the government that just testing one time is not good enough. It's not a vaccine. Today the guy tests, tomorrow he walk out, he get infected, he come back to site, he will infect the rest of the people. So there has to be a periodic testing. And this cost for periodic testing, like in our neighbor Singapore, is actually borne by the government. So to be fair, so in our case, I think the government should look at it and what can be done to alleviate the hardship of the people in the industry. We are already badly affected, and it's the role of the government to look at how to reduce some of the pain that we have.
Okay, good. There's one question for Mr. Dato Jeffry. This is regarding the, do you foresee any cases of projects abandonment happening due to the borrower's inability to service their loan? In other words, what you call the borrowers itself having an issue with their payments, and then subsequently they are actually not able to service their loans, and then thus resulting what we call the project's abandonment. Your views, Dr. Jeffry?
Yeah, probably first and foremost, Dato, I think this is two parts here, to the borrower as well as probably to the property developer, right? Now, as far as the bank is concerned, number one, for the end financer, we will definitely continue to honor the disbursement to the obligation to our developers lah. Meaning, as per progressive claim by the developers, they submitted the e-billing with the architect certificate and so forth. So we will continue to disburse the facility. Meaning, when we disburse the loan by our borrower, our end financer, is supporting the property developer. Hence, it will not. We say that the project will not be abandoned. Because as long as the developer submit their bill, their e-billing to us, we will continue to disburse the loan, right? I mean, as long as it is being supported by the architect certificate and so forth. I think number two, on the aspect of, say, the bridging finance, the bridging loan, the project itself, same thing also. We will continue to support the project developer in their bridging financing, right? I guess in the context of our developer having a project, we also assist them in terms of even the moratorium, the 6 month. We have a 6 month moratorium which was granted to the property developers. The repayment holiday between March and September that day, we also granted the moratorium, and we also have the ongoing repayment assistance. We call it the RA, which are tailor-made to the needs and the requirement of the contractor as well as to the property developer. Hence, with all the support, we don't see the project to be abandoned, right? And we also see our level best to support the contractor, the developer itself. I think my third point probably, even I think earlier that Mr. Raj talked about the COVID-19 act on the housing development laws, right? So like all these late payment charges, whereby the bank will not be probably charging late payment charges, delivery of vacant possession, the defect liabilities. All these are supporting the developers, right? And as far as the industry is concerned, I guess these are supporting the developer. And we as a bank, we definitely also will support the individual buyer in terms of the restructuring of their repayment. So with all this initiative by the bank, we don't see any, or we don't foresee no case of project abandon, Dato Charlie.
Yep. But basically, will Maybank be ready to allow for payment of interest only for the next 2 years? Because that would actually then, instead of moratorium, the borrowers can actually pay only interest and then restructure the repayment or the loan repayments over a longer tenure after that. So, in other words, a new scheme of
right. Yeah. We do have our package, our financing package, whereby for the borrower, we call it a Maxi Home Easy financing. Meaning for the first 5 years, to have the borrower, they just basically need to service the interest. So we don't have to pay the money installment. They just need to service the interest for the first 5 years. And yeah, this basically to ease the cash flow of the borrower. Other than that, to ease the cash flow, we also do some kind of extension of loan tenor, from say 35 to 35 years or until the age of 70, whichever is earlier. So all this will basically support our customer, our borrowers. And there are certain projects under those government initiative home financing. We can even offer a tenor up to 40 years. So with all this, extension of just payment of interest only, extension of tenor, we hope it will support our end finance, the buyer being the end financer of their purchase of their home. Dr. Charlie, yeah.
All right. Thank you, Dato Jeffry.
Yeah.
One more question that is on the board. Can the contractor claim for variation under PAM clause 4.2? That is inconsistency between the contract documents and the MCO or CMCO's SOP. The contractor may argue that compliance to SOP on the change of working conditions, procedures and environments would then allow the contractor to claim for variation under PAM clause 11. Mr. Raj, you have any views on this or answers?
Yeah, I think it's a very creative use of those provisions, I must say that it looks interesting, although I am not sure that it will work. I mean, on the face of it, yes, I was just looking at the provision, and he basically saying that there is an inconsistency between the requirements and the contract documents. But that inconsistency that has been intended, I think you must take a purposive interpretation of the contract. It's not so much something that came about later. It must have been at the time that you were drafting the contract, or you signed the contract. There were certain inconsistencies with statutory requirements. So then the contractor points it out to you, and that becomes a variation. But in a situation like this, because it's a supervening event, neither party knew that this was going to happen. So I really think that it may not succeed, in my view.
Yeah. Okay. One more question on to Ms. Datuk Soam. What would be your advice to member developers who already foresee that they will not be able to achieve their completion date? Should they start discussing with their contractors or straight away apply for an extension of time?
I mean, when you say cannot complete, means it's your obligation with the buyer or the contractor?
I think both. One is the obligation to the buyers that you can't complete on time in order to deliver. The other one is whether the contractors is not able to complete on time, whether when they claim for extension, what is, do you discuss, do you talk to them, or do you apply the contract straight away?
I think like we say, it's two part of it. Your contract with the buyer is your contract with the buyer. Your contract with the contractor is your contract with the contractor. It's not interlinked here in this aspect. But of course, in the normal contract administration, we usually have a completion date earlier from the contractor before we actually get all the certification, the CCC, and then only issue the VP to the buyers. But if you are very clear that you cannot complete on time and cannot meet the obligation with your customers, the recourse under the COVID-19 Act, I think, is limited to the 167 days. Or if you cannot complete by 31st of August, as mentioned, you can apply to the minister for an extension up to 31st of December, okay, which is another additional 122 days, which when you add up with 167 days will be 289 days, okay, from 18th of March. Okay, that's the period that you're going to get. Because unless the Act will be actually extended, because the Act is coming to an end on the 31st of December. And as for your contract with the contractor, you will then have to use the pen form of contract to actually administer the contract. So what is allowed in there and what are the provisions that are allowed, and because of this COVID-19 bill that's out there, and what are the actions that you cannot do against your contractor. So I think it's laid out. We must read the pen form of contract in addition to the COVID Bill Act, and your obligation with your buyer may be separated from the contract that you have with your contractor in this instance. So recourse between you and your buyer, you look at the COVID bill, you have probably up to end of December, that will give an exclusion of 289 days from your completion date. Okay, and as to your contract with the contractor, you have to administer it based on the pen form of contract and the COVID bill as well.
Because currently there is a lot of discussion on the what you call loss and expense as a result of extension of time. Now, because of COVID-19, MCO, this is actually a neutral event which neither party is a cause and neither party contributes towards it, but both parties suffers. But at the end of the day, contractually, it always says that, for neutral event, there is no claim for loss and expense. So a lot of developers will say that, no, sorry, this is a neutral event. It is COVID-19, no loss of events during that, what you call extension of time. So what is your view on this, Dato' Soam?
I think Raj just now did mention, because the pen form of contract luckily did mention there that epidemic is actually a force majeure event. And under the force majeure event, during the force majeure event, you get the time, but there's no loss and expense. So it's quite clear if you're using the pen form of contract. But what Mr. Oliver just now raised up was that most of the contractors' relationship with their subcontractors and labor subcontractors are not using the pen form of contract, and there's no mention about force majeure or whatever inside there. So it may be a bit different. So in our instance is that the main contract between the developer and the contractor, I think if using PEM of contract, I think it's quite clear. Okay, and as for the NSC as well, it's also covered in there. So it's actually quite clear as to whether loss and expense is possible. But just now one gentleman did ask a question under clause 11, whether Raj already answered that, whether it can be used or not because of the differences between compliance and also the contract document. So that's a bit different, the angle that is trying to come from. But if you look at the pure surface of it, it's a force majeure event. You get the time, but there's no loss and expense. But I think everything is subject to discussion, like what Oliver mentioned. A lot of time, a lot of contractors have long-term relationship with the developers, and the developers may, on compassionate ground, see how to adjudicate this matter. And on the reverse, for a lot of time, because of the long-term relationship, a lot of contractors, because if the cost is not a lot, the contractor will absorb it because they just want to move on with life and move faster. Because while waiting for decision, sometimes can be dragging, and then you lost, and time is the essence in all contract.
Actually, basically under Section 7 of the Act itself, it is the inability to perform as a result of the PCID Act, right? So basically, any event that occurs outside the PCID Act would not be applicable. Now, let's look at the scenario when the construction workers, as a result of inactivities on the site, they can't be staying there and waiting for things to happen. They have actually decided to return home. And you can see actually boatloads of foreign workers have actually returned home and unable to come back. So in this aspect, when they start to mobilize back the works again, there is actually a half pace or operations which is not fully mobilized. Then there will be some delays as a result of it. Is that a cause for what you call extension provided by COVID Act? Looks like it doesn't. Or is there a claim under the actual contract act itself? Mr. Raj, you have any answer for this?
I think you are right. I think you are right in the sense that the COVID Act, the duration is limited. So after December 31st, for this part, I think you can't really look to it unless it's extended. Under the PAM contract, for instance, again, we are looking at the impact of the force majeure situation and how long the force majeure situation continues, So the contractor would have had to give a notice of force majeure, and when he resumes, I presume the first force majeure is no longer applicable, and then he has to perform according to his contractual obligations. So then that will be a problem because it's going to be difficult for him to say that because of the COVID-19 situation, my workforce has demobilized and gone back to wherever they came from. I only can mobilize 50% of my force, and I can, therefore my productivity will be much less. So I think it's going to be a tough call. But as I said before, this is something that also affects the developer in the end. So the developer as well has got an interest in supporting the contractor to overcome some of these problems. So it may be something that's a commercial or something that you work together outside the contract. But I think neither the Act nor the contract actually helps in this particular situation.
Okay. I think I agree. I think maybe Dr. Charlie, I just recap. We have the MCO from the 18th of March to 12th of May. Okay, remember, we have MCO 1, 2, 3, 4, but it's 18th of March to 12th of May. And then we have the CMCO from 13th of May to 9th of June, RMCO from 10th of June to 31st of August. And then then the RMCO got extended to 31st of December. But then in October again, in the Klang Valley and some of the states, the CMCO came back and was from 14th of October to December 20th. Of course, we don't know whether it's going to be extended or not. So in part of Malaysia, so it could be extended. So from MCO to CMCO to RMCO back to CMCO. So the question is, during the time of the MCO, at the start of the MCO, actually both REHDA and Master Builders, we did jointly went to see the ministers involved. That was in the later part of March. I think we actually approached the minister to say that something need to be drastically done for the sector to be revived and be one of the first few. They started by giving 10 sectors to operate, which is essential service. We say that the next best should be ourselves. And that's why, this process of applying to MITI and getting approval and all this, it was a very lengthy process. And they don't understand, I think the government doesn't understand the supply chain issue. You cannot just approve a contractor and then don't approve the professional who is supervising. Or you approve both of these, but the guys supplying you concrete or steel bar and all this are not given approval to operate. So this truncated approval, I use truncated approval given, actually is no help to the industry. And the industry was able to start applying from, I think, 13th of April, if I'm not wrong, if I remember correctly. But before any contractor can get onto site, then we have the first cluster that happened in Jalan Ampang, construction cluster. Then the minister then said that all construction sites, you must have mandatory testing. We don't have the infrastructure to do the testing, okay, causing huge delay. So the effective construction work actually did start sometime towards the later part of May. And then by the 11th of June, an announcement came out when the CMCO came about, RMCO came about, the government said that, okay, from 11th of June, all construction workers need not be tested before you can get back to site. You just need to register and then you can go back to site to work. That's where work then start normalizing, I would say, from that day to where we are today. So, so I urge all the parties concerned, especially the developers and contractor, can sit down together, look at the reasons behind it, and also I would say the reduced productivity for the period from May till maybe after 11th of June. Okay, the reduced productivity, and then from where it picks up maybe to 50%, 75%, 80%, 90%. I think the architect being the SO at the site can actually adjudicate in this instance and then give the appropriate extension of time to the contractor. And the parties need to sit together to see how to address this issue. Maybe Mr. Oliver, you have other ideas. Maybe you can think about it. This is a way that I believe can be resolved. Looking at the days, looking at the events, looking at how we move on from the reduced productivity to normalization and the impact that it has.
Yeah, I fully agree. Even though it's subjective.
Okay,
Sorry. So even though it's subject to site-to-site situation, but at least this is a way that both parties can sit down and compromise and accommodate each other, rather than just filing a claim. When you're filing a claim, you will not know who is right, who is wrong until the judge is giving you a verdict, you see. And the important thing now...
You make Mr. Rush rich, you make Mr. Rush rich.
That's right. So I think for contractor point of view is to move on and, if possible, we will have some reimbursement. If possible, we will have some indication of where is our liability is. Else, it definitely is, there's no light at the other side of the tunnel.
Yeah.
Right.
Okay, another question is on this defects liability period. The extension of defects liability period is not a fair extension, as any defects occurring during the MCO period is also being rectified, even though it can be done only after the MCO. So these are what you call questions that if it is 24 months and then you extend another, say, 6 months, it becomes a 30 months DLP. Now, the product has already been completed, and thus it's only valid DLP for 24 months. But by virtue of that MCO, you actually extend it for another 6 more months. Then the developer or whoever got to actually sort of bear the liability for that extra period. Although we say that any defects that occurs during the defects period will be rectified immediately after the MCO. So it has to be done fast, and it will be done within the period of time that is extended for them to repair. So is that a fair evaluation for defects liability period? What's your panel answers, Dato Soam?
Maybe I start off first, because I was involved in trying to come up with the first COVID bill requirement. And actually, we discussed at length on this defects liability period. What we felt was that the balance of the defect liability period that falls during the period of the MCO, and where contractors and the suppliers and the NSC and all this couldn't go onto ground to actually do the defects, that period be then extended to whatever defects liability period there is, to be fair lah. And not a blanket 167 days to be given as per the current contract now, which actually creates a bit of a problem. So, but then since this is in the Act now, I would say that whatever defects list that has been given previously would have to be rectified by now. I believe that falls during that period. Whichever contractor or supplier would have rectified by now. Unless there are parts, example, maybe you are M&E or your leaves or whatever, the parts is coming from a country that is still under lockdown, then it's a different story. Then you probably has to wait until the country has a lifting of the lockdown or whatever before you can deliver the material. Otherwise, whatever defects would have been rectified. And I believe that if you're so unlucky up to 31st of December, now the date is extended for another 167 days. Beyond December, there is still issues with defects. Then I think you probably need to discuss with your supplier or contractors on how to maybe address this on a per event reimbursement or whatever in this instance. Otherwise, if it's over a 2 years period, the defect liability coming to an end, I think most of the major defects would have been rectified by then. I believe so. So that's why I say a lot of the event are actually now over. And if we say correctly, there are a lot of dead bodies along the way already.
Mr. Raj, you have anything to add on this?
Yeah, I think probably that's about. I think I would agree with Dr. Soam. Has just stated, the thing is, most of the major defects would have manifested themselves. I think you just got to work out a reasonable arrangement with the contractor to address the extended period, maybe on a per job basis or something. But there's one thing I also want to draw people's attention to, which may not be so apparent. A lot of people think that the developer's obligations end at the conclusion of the defects liability period. That is only your obligation to come back and repair. But your liability in damages for breach of contract, if there are defects, lasts for the full 6-year limitation period. That's something not very well known. So the thing is, it's not as if you are losing out too much. It just means that you are still obliged to personally come back with your contractor rather than to leave the purchaser to go off and get his own contractor to repair and get an indemnity from the developer.
Okay, I have a question for Mr. Oliver. Now, the saving provision in Section 10 of the Act protects any termination of a contract, forfeiture of performance bond, or any equivalent, which happens during the period from 18th of March until the enforcement on the 23rd of October. So what's your view on this, as this would mean that the interests of the contracting parties, which are directly and genuinely affected by the measures under the PCID Act, would then be compromised before the commencement of the COVID-19 Act, which means to say you are prevented if during that period any legal action that is actually been taken or any claims that has been officially put in, the parties actually has to allow it to happen. And so would that compromise the rights and liabilities of the parties before the commencement of the COVID-19 on the 23rd of October? Mr. Oliver, you have an answer for this?
Yeah, basically, we have not heard much on calling on the performance bond. In fact, before this session, I have spoke to Raj. Actually, according to him, there are some bond that has been called. If it is really due to the COVID situation and before the implementation of the Act, I think it's too bad where parties are either taking advantage or it's a real genuine case. One party think that the other party is non-performing. In fact, at that period of time, the contractor also facing some issue where they can't really enforce the education call, the CPA, where there was no director under AIEC. there was no appointment of educator. So contractor also quite suffer at the time of, your work has been delayed, your payment was delayed, and you can't get a CPA at that period of time before the director was appointed. But other than that, I think calling a bond, if it's a genuine case, probably if it's due to non-performance or other taking advantage on the COVID before the COVID implemented. Perhaps Raj can share with us on some calling bonds issues.
Yeah.
I think Mr. Raj, you will be the best person to answer this.
No, I mean, this is actually a live case at the moment, so I cannot mention names or give too much detail. But a bond has been called, and the contractor takes the position that, look, you cannot call on the bond during this period of the COVID-19 Act. But I think the question, as I pointed out earlier when I was doing the slides, is was your inability to perform caused by the measures taken by the PCID Act, or whether or not it was due to other reasons, because if it is due to other reasons, you cannot hide behind the Act. That's one problem, you have to directly relate your inability to perform to the measures taken under the Act. But I think the more difficult one, which has not been addressed at all, is that the bond will come to an end before December the 31st. So if you can't call on the bond and the bond comes to an end, then effectively the owner or the employer has lost the security that he otherwise had, which can't have been the intention of the Act, because the Act was only supposed to give breathing space and suspend everybody's obligations during that period. It was not meant to lead to a situation where one party actually loses its substantive right or security. So I don't know whether or not that's how the courts will interpret it. If you just read the Act literally, that's it. But normally courts try to do justice, especially if the council guide them correctly. They will try to give some sort of interpretation that will help to preserve these rights. So left to be seen. I will report back to you when the case is finished.
Okay. I think there is one question here which is regarding PAN form. What is the provision in the PAN form for compliance with legislation, and whose cost would it be? I think this particular question actually refers to workers' quarters and the provision of a face mask covered under this under this legislation, but it's not a variation regarding different work conditions as contemplated at the time of tender. So when it's unforeseen in such case, but in order to comply, especially let's say the workers' quarters, the additional measures that is to be taken in order to administer the site, where is the clause that allows a claim to be happen? Anyone? Mr. Raj?
I don't know. I didn't think that that there would be a right to a claim for this kind of situation. I think it would only apply to a situation where there is because when you're having a change of legislation, this happens very often. You forget about the COVID situation, but sometimes there could be other situations where there's change of legislation that results in additional costs. And in those sorts of situations, in the past, whenever we have tried to run an argument to say that the contractor is entitled to more costs because of compliance with the legislation, we've always failed. For example, like the control price for certain material, for instance, if it changes and then suddenly there's an increase in cost, it's unfortunately a risk which is borne by the contracting party generally, So I mean, I can't see any obvious clause under the PAN contract that would allow you to now make a claim for the more additional costs you incur for complying with the new legislation or regulatory requirements to cope with COVID-19.
Okay, there's one question for Dato Jeffry. This is regarding financing. Post MCO, during this MCO, we noticed that end financiers are getting stricter in approving end financing, either much lower margin or additional terms such as additional funds availability. Looks like end financiers are actually tightening approvals. What's your view on this, Dato Jeffry?
Yeah, thanks for that question. I guess the main thing is we are basically assessing the individual borrowers here, right? So whether or not we are tightening, I think we are not tightening, but it's all on the individual personal capacity of the borrower when they approach the bank. So what I'm saying is, maybe just because we need to be a bit detailed on our scrutiny, right? With this particular borrower is have a sustainable income. As we all know that there are many of job retrenchment and so forth. So we just need to do a bit of checking as far as underwriting is concerned. Yeah. As far as the eligibility of the loan, eligibility of the customers, actually is pretty much the same. But how do we assess the individual borrower based on their sustainability of income? Based on their, are they still gainfully employed or not, or are they still, able to come up with the debt service ratio that required by the bank? So those the assessment that we need to do. But we are not say that we are tightening the credit per se. I think we are not. Pretty much on doing that a bit of assessment on as far as the applicant are concerned when it come to the end financing. And this is where I think pretty much we work hand in hand with the developers, right? The developer also they are doing their own first-hand assessment of their potential buyer, and we basically know how is the financial standing of each of these potential buyer. Hence, we will give them the financing. But on our part, we do a bit of checking as far as their eligibility and so forth. So I would say that to Charlie is pretty much still the same, but just that we need to do a bit of credit assessment to this particular borrowers. That's it. Thanks.
Okay, Thank you, Dato Jeffry.
Yeah.
Okay, one last question is actually regarding commercial SPAs. COVID bill only addresses EOT between developer and buyers for HDA projects, which means housing development projects. What about commercial SPAs? Does the COVID bill have any effect on that? Or will the SPA signed between both parties then take precedence? Dato Soam, you got an answer for this?
I think this one you need to refer back. I think this one you need to refer back to Section 7. You cannot run away because it's not covered under Part 11, okay, Clause 32 to 38. So this is inability to perform based on other forms of contracts. So you need to rely on that and also on your existing agreement that you have between you and the buyer based on the commercial basis. Because it's not on the standard form. So we do not know what is in there that you have signed between yourself and the buyers.
Okay, good. I think I have just one more last question before we wrap up the forum itself. This is a question dedicated for Mr. Oliver. There have been a number of COVID-19 clusters linked to workers in factories, in construction sites, like for example, in factories where Top Glove is involved, and construction site where Pavilion, Damansara, and all the other clusters that's occurred. How are your members actually coping and addressing this issue? What are the measures that is to be taken? And also, what are the solutions actually to resolve most of this? All right, Mr. Oliver?
Yeah, I think members are quite conscious on this, and many have sent their workers for testing, even though we don't know what is a regular or interval we need to. But we are in the process of test all the workers on site. We are improving the so-called the cramped areas that the workers' quarters on site. Knowing that there is an Act 446 that which implemented years ago, but I think we need some time to improve the situations. So we can't do it overnight. But contractor on sites are actually doing all these precautions because they're so worried that the workers will get infected again and spread over again. Because every time we face this, the site will be sealed, the work will be suspended. So the punishment will fall back to us again, you see. So we are very cautious on all these things. Abide with the strict SOP and things like that. And hopefully, I mean, we realize that most of the infection are actually come from the foreign workers, where the condition of staying in the quarters are not so ideal. I think many sites are improving on that situation.
Okay, thank you so much, Mr. Oliver. We have actually come to the end of this forum today. And just as a reminder to all our participants, we have also another part 3 of the REHDA webinar series. And this time, we are going to concentrate on part 11 on basically the HDA Act itself. And get ready and also come and join us on this coming Friday on the 18th of December. And with this, I would like to take this opportunity on behalf of REHDA to thank Dato Soam and also Dato Jeffry, Mr. Rajendra, and also Mr. Oliver. Thank you so much for joining us this time. And let us all, hope for the best, that the COVID-19 will assist more than to actually disease. Thank you. And
Yeah, thank
see you
you.
all again. Okay.
Thank you.